purchase, spousal rights with respect to real estate on a mortgage or refinance. We want to talk about the difference between a common law and a married spouse. We want to talk about what is the matrimonial home. We're going to talk about separation agreements, and then we're going to talk about common problems we see with real estate transactions. What I'm showing you is a screenshot of what we see in the government system. And so by showing you what we have to select in the government system, it would help you understand what we have to do and the things that we're looking at. So there's family law statements that we have to select whenever we're selling property. If there's two people on title, we have to select one of these statements. So the statement number 2 says this property is not ordinarily occupied by me and my spouse who is not separated from me. So in that instance, that we would select this if it was, let's say, a rental property. Two people are on title holding a rental property. They're saying this is not our normal principal residence and we're not separated. Okay. It could also be the family cottage. All right. Statement 3. Name and I are spouses of one another and both parties to this document. Well, that's where, let's say, the two people are on title are also two people involved in the transaction. So we have to select this statement 3 for both people, and we have to put the other person's name in. So it would be Jane Smith and I are spouses, and then Jim Smith and I are spouses. We have to select it for both people on title. I am a spouse and I am transferring to myself to sever joint tenancy. So joint tenancy is typically where married couples are registered on title to hold title as what's called joint tenants. And in that instance, there's what's called the right of survivorship. So if one of the joint tenants dies, the remaining joint tenant automatically gets 100% ownership of the property. Now, this clause says, I am a spouse and I'm transferring to myself to sever joint tenancy. We would typically select this in the instance where they're separating. Now, remember, separated parties are still spouses. They are no longer spouses once they become divorced. But in the meantime, they're still spouses. So that's why we would select this. And what that does then is it stops that automatic right of survivorship. So therefore, if one of those spouses was to die, then their portion would transfer through their estate, which would mean through their will. And at that point, it would go to their beneficiaries. So maybe in that case, let's say their children. Right? They select that because they don't want their spouse to get the remaining portion of their property. Next, 5. Spouse, my name is my spouse and has consented to this transaction. Now, this would be the instance where it's a principal residence, but there's only one person on title, and both parties live in the property, but the other person is not on title. Maybe because they have a job of high probability of being sued, or they're doing it for credit protection or anything such as that, so they don't go on title, or maybe they just couldn't qualify for the mortgage. Right? In that instance, the one person went on title, both people live in it, it's the matrimonial home. And the person that's not on title has to sign off in order for the person on title to sell the property. Okay. Number 6, this property is not designated under the Family Law Act as a matrimonial home by me and my spouse, but there is such a designation of another property as a matrimonial home. So this would be, for instance, this is, let's say, the cottage. They're saying, this is not our matrimonial home, or it could be a rental property. This is not our matrimonial home. There's another property that's our matrimonial home. Okay. Number 28, I am separated from my spouse and the property was not ordinarily occupied by us at the time of separation. This is a big one. So if let's say Jim and Jane live in a property together and they separate, let's say Jim moves out of that house, right? At that time, because Jim and Jane were in the house prior to the separation, Jim or Jane, whoever left the property, would still have entitlement to that house. So let's say Jim left. So Jane would not have the ability to sell that house without Jim signing off on it because it was the matrimonial home. Okay, that's a very important one that eludes a lot of people. People think, oh, well, my spouse left, they gave up all the entitlement to the property. They want nothing to do with it. It's now, let's say 7 years later, 10 years later, I want to sell the house. You're now in a little bit of a tricky situation because you need to get that person to sign off on the property. Even 10 years later, the fact was it was the matrimonial home at the time of separation and nothing was done at the time of separation to transfer that property. So you still have to get that person to sign off. Okay, and that's a tricky one. You got to be very cognizant of. I've seen this happen where one of the spouses has returned back home to their home country. And we had to go through the process of getting them to sign with a lawyer in their home country to allow the remaining spouse in the property to sell it. And this happened, I think it was like 10 years later it happened, but we still had to go through that process. So that's why it's very important if you're ever running into this scenario to make sure you get something signed right away from them. Get the title transferred right away. Get a power of attorney, a limited purpose power of attorney with respect just to this property that allows you to transfer this title. But do something right away. Don't allow this situation to continue. Okay. And this also would be the same thing for when listing properties. If it was the matrimonial home at the time of separation, then the spouse that left the property would still have to also sign off on the listing documentation. So for Sam's instance here, right? Statement 7, my spouse has released all rights under the Family Law Act by a separation agreement. There's the saving grace to number 28. A signed separation agreement would release all rights, and therefore the title could be transferred. Okay. Number 8, this transaction is authorized by a court order. There's also the saving grace for number 28, a court order. If in the event there's no separation agreement, but it goes through the court process and no court order says yes, Jane gets the house, well, then that court order can be relied upon in order to transfer title and or sell the property. And this property is released from the application of the Family Act by a court order. Once again, a court order. Okay, so those are the scenarios that we have to select. We have to select at least one of those in the instance that we're trying to sell property with 2 people on title. Okay.
Selling your home during tough times, whether you're downsizing, divorce, or debt, we understand the unique challenges you're facing. Introducing our specialized real estate solution to help you navigate these difficult times with ease. Selling a home can be overwhelming, and yet our experienced team will guide you through the process, providing personalized strategies to maximize your home's value. Whether you're downsizing, going through a divorce, facing debt, we'll help you sell your home and start anew. Don't let these challenges define your selling experience. Let us turn them into opportunities. Visit our website at affluenceregroup.com to learn more.
Now let's talk about purchases. Let's say Jane and Jim were on title. Let's say Jim left the property and Jim went to buy a property. Well, Jim doesn't need Jane's signature to buy property. There are no family law statements to select when purchasing property. So we have seen this in instances where, let's say the couple are separating. What happens is one of the spouses will go off and buy another property. Or I often get the same question, like, hey, Jeff, can I go buy another property? The divorce isn't settled yet, not finalized, but can I go buy a property? The answer is yes. You don't need your ex-spouse or your spouse, who's not yet your ex-spouse, but let's call that person your to be your ex-spouse. You don't need that person to sign off in order for you to buy that property. Now let's talk about when you want to refinance the property or put a mortgage on the property. These are the selections we have to choose. Once again, we have to choose one of these under the Family Law Act. Number 2, same statement we saw as the previous one. This property is not ordinarily occupied by me and my spouse, who is not separated from me as our family residence. So once again, these people are saying this is not their principal residence. So this would once again be typically a rental property, investment property, the family cottage, anything such as that. Okay. Number 28, there's that tricky 28 again. I'm separated from my spouse, and the property was not. So this is a different one. And my property was not ordinarily occupied as at the time of separation. So this is saying, hey, this property was not our principal residence at the time of separation. Okay. Number 3, name and our spouses and both parties to this document. Once again, both parties on title, both parties signing off on this document. 24, the charge. So a synonym for mortgage is charge. So if you imagine, a mortgage is like a loan that is not you can't borrow off it again, like a line of credit. So there's a loan and a line of credit. Now, in the worlds of mortgages, we call them in a mortgage and a HELOC, and together, what is registered on title is called a charge. So we call them charges. Okay, so the charge is subject to the spousal interest of my spouse. Okay, so this is where it's saying, yes, this mortgage is subject to the spousal interest of my spouse. Okay, and number 5, the spouse has consented to this transaction. So once again, if only one person is on title and it's a matrimonial home, but both people live in the property, then the spouse on title has to turn to their spouse who's not on title and say, hey, you have to consent to this transaction in order for that mortgage, that charge, to be registered on title. Number 6, this property is not designated under the family law as a matrimonial home of my spouse, but there is such a designation of another property. Once again, saying a rental property, second home, such as that. So we don't need, so if it's, let's say, a rental property, and let's say Jim is on title to the rental property and Jane is not, Jim doesn't need Jane's signature to put a mortgage on the rental property because it's not the principal residence. It's only the principal residence wherever they need both signatures. Okay. And once again, you have those same ones. Number 7, released all entitlement because of a separate agreement, court order, and number 9, court order. Okay. So those are the things that we have to go through when we are registering title. We have to look at the title and we have to figure out the family law statement. So if you're looking at selling, buying, or refinancing, your lawyer needs to know this information. We're going to reach out. We're going to ask you your family law information, right? We need to know the status of your marriage. We need to know what's happened in that, because it's under the Family Law Act. We are required to put this information down. So let's talk about common law and married spouses, okay? So under the Family Law Act, married spouses have automatic rights to property, equalization, and support, okay? Common law spouses, on the other hand, are only automatically entitled to child support or spousal support. So they do not have automatic rights to real estate. This is a misnomer. A lot of people think that if they have their common law partner move into their property, their home with them, that they've suddenly given up half the entitlement to their real estate. Incorrect. There is no automatic entitlement to real estate. Okay, so that's a very important one. But I get that question all the time. Hey Jeff, what do I do? I want to have my common law girlfriend move in with me. What do I do to protect my home? Don't get married. All right. I'm not saying that not to get married. I'm obviously a fan of marriage, but I'm just saying that's the simple answer, right? Because once again, common law does not have automatic entitlement to real estate. So a person's right to property is determined by their spousal status. So here I'm going to explain the difference between common law and married spouses. So a married spouse, obviously you've gone through the whole legal process to get married, you have a marriage license. But what is common law? So common law is determined, and it's called determined under the Family Law Act. And here's how we determine it. So common law is persons who are not married, but who have lived together for not less than 3 years. Okay. A lot of people think, well, hey, you know what, Jeff, I've lived together for 6 months. Are we now common law? Because a lot of people think that's, once again, people think that living together for 6 months is common law. Wrong. It's 3 years. Living together in a continuous relationship for 3 years makes you common law.
And Jeff, if someone owned a property and then they get married in that property and they've owned it first, is that considered a matrimonial home? What happens in that scenario?
Good question, Sam. I'm going to get to that one next, okay?
Okay, great.
That's a good question. Perfect segue, okay? There's 2 ways to determine common law. One is you've been living together for a continuous time of 3 years. So let's say after 20 months, they move out for, let's say, 3 months, and they move back in. Well, the time that they separated to come back restarts that clock. So it's not like 20 months and then 10 months after. No, it restarts. So it has to be 36 months, 3 years from that moving back in order to become considered common law. Okay. And once again, common law is only about child and support payments, right? It's not about real estate. Further, a second way to become common law is if you are in a relationship of some permanence and you have children together. So provided you have children together, you don't need to have to meet the 3 year threshold. It can happen a lot earlier, provided you have children. So talking about the matrimonial home, great segue. Thank you, Sam. So the matrimonial home, so married spouses have automatic entitlement regardless of who is on title to the matrimonial home. So if you understand it this way, the matrimonial home, imagine, is like a black hole. Jim owns a property. He's owned it for 20 years. He's paid it off. There's no mortgage on it. He marries Jane. Jane moves into it. Automatically at that point, Jane is now entitled to half of the property, regardless of the fact that Jim's owned it for 20 years and paid it off. Right? So hopefully that answers your question there, Sam.
Absolutely. Okay.
And so it's important to know that this could also, it could also just not be limited to the matrimonial home. If there's another property which is designated as a family residence, where people spend a large portion of the time together, then that property could also be brought in to this equation and considered a principal residence, the matrimonial home. So for instance, let's say snowbirds. Snowbirds might spend 6 months in a day here in Canada, and then go down to the States or Florida in 6 months less a day at another property they have there. that would then bring those both properties in under the equation as matrimonial homes. So as long as the property there, and then in that case, once again, if Jim owned both of them and paid them both off, or Jane owned both and paid both off, the moment they become matrimonial homes, half that equity, half the value of them goes to the new married spouse. And that's like I say, it's sort of like a black hole. The value of it is split 50-50 in the event of death. Okay. Now, in order to arrange an uneven distribution, that's where in the event of sale, this is where it's best to do it at the very beginning, prior to the marriage, and what we call prenuptial agreements or marriage contracts. That's where that has to be, the determination or the arrangement has to be determined prior to marriage. It can't be determined after, because at that point, once again, automatic entitlement upon marriage. All right, so let's talk about separation agreements. Now, mortgage companies often require, so step one, why get a separation agreement? Well, when looking at getting a new property, mortgage companies often require separation agreements. So if you're looking at, let's say Jim and Jane are looking at buying properties, well, if Jim holds the property and Jane goes off to get another property, she gets a buyout. Well, the mortgage lender that she's going to use to get that new property, if she is going to do the mortgage, is going to want to see a separation agreement, because they want to see that she no longer has any entitlement to the property she left behind, and that she has no responsibility or liability to pay for that property. They're going to want to see that, right? And another great aspect of having a separation agreement is it allows for us to transfer title. Let's say Jane stays on title and Jim is leaving title, and Jim is transferring title to Jane. Well, if you have a separation agreement, we can transfer title and avoid the land transfer tax. We can waive the land transfer tax, which, especially now with the values of properties, we all know that the land transfer tax can be quite astronomical. So the cost to create a separation agreement is substantially less than the land transfer tax. So just from a financial perspective, it's much better to have a separation agreement to avoid that land transfer tax, right? It's called smart tax planning, okay? Now, it's important to know that from a legal perspective, a separation agreement can just be handwritten, even on a cocktail napkin. But from a pragmatic perspective, no mortgage lender, law office, or anybody else would take or accept that, right? But it can be done legally. It can be done, but it just, pragmatically speaking, it's not acceptable. It wouldn't be accepted from a business perspective. Mortgage lenders would not accept that at all. Okay, and so there are certain requirements that have to be met when drafting a separation agreement, and one of the most important things is full disclosure. Okay, full disclosure. So full disclosure means that in order for the separation agreement to be valid, there has to be full financial disclosure from both sides to each other. One of the biggest abilities to strike out a separation agreement is when one person says, "I didn't know he had a property, other properties, or what his business makes, or what other assets he might be hiding from me." Right? So there has to be full financial disclosure, because then that way there's informed consent. They're consenting to the separation because they're informed with the full knowledge of what's happening. Okay. So that's an important part. The other thing is the separation agreement has to mention the property. In order to avoid the land transfer tax, the separation agreement has to mention the property and who's getting the property. So common problems that you would need to be aware about, common problems mortgage brokers and realtors all should be aware about, okay? There could be, and this is an obvious one, it's very self-evident, due to the separation, there could be delays in the closing and the time of the closing. For instance, if the parties are still don't have a signed separation agreement, then it's not unsure, and we can't disclose, we can't release the money, right? If the parties are have lawyered up, as let's say, and are going tit-a-tat with lawyers, well, then those extra costs are going to eat away at the equity or the payout for each party. Okay.
And Jeff, how long does that time period when someone starts that process of the separation agreement? I know it says 5 years about funds, but starting that process of the separation agreement, how long does that process usually take?
So the process to start is create a separation agreement?
Yeah, to have that done and then to know who's getting access to what.
So it's a good question. The process can be, it's very dependent on the parties. So we've done some separation agreements where it took maybe a week or 2 weeks. because they didn't have a lot of assets, they didn't have children, they didn't have pets, and they were very amicable about the separation.
Right.
We've seen some that have taken, I'm fairly certain you could talk to any family law lawyer, and they have some that have taken years, potentially 10 years. It couldn't take a very long amount of time. And once again, the more complex the estate, the more complex the relationship, the more assets, children, pets, there are compounding elements on whether or not they're getting along can just make it more complex and delay that time. Right. So it's a good question, but it really is fact specific each time, and it's person specific, whether or not they're finding it easy to get along and communicate.
Makes sense.
So here's an important part. Let's say we sell a client's property. If there's no signed separation agreement or no signed direction refunds, that money has to stay in my trust account. I cannot pay the money out to one person or to the other person. That money has to stay there until both people agree and sign the separation agreement, or until both parties sign a direction refunds, like a direction telling me how to disperse those funds.
So it can still close. It just won't be. It will be held in the trust account.
So we can still close the real estate transaction. We would still pay out any mortgages, real estate commission, property taxes, anything such as that is applicable to be paid on closing. But the net amount would have to stay in our trust account until something's been signed and we've been instructed to pay that money out. And I've seen it before. Like, this can take a vast amount of time. Most people get it done within a few months, but I still have money sitting in my trust account right now from a deal that closed 5 years ago, because those people still haven't come to an agreement on who's getting what. They're still fighting it out. Okay, so these are some of the problems that do happen. So it's best to try and get a separation agreement signed as quickly as possible. And if you need help, there are family law lawyers, or there's also mediation services. Either one of them can help get a separation agreement and get it signed. Okay. So we are excited to announce this year that you can now find Rabbit Law on BHB TV. So BHB TV is a channel that you will find on smart TVs, and you can follow us there. You'll see presentations like this on our TV channel on BHB TV. Okay. So we are known, as I talked about, how we invented the remote signing process, and then we had a pivot when COVID happened, and we did the virtual signing process. So I have a little video here which just shows our signing process, and I'm just going to play that for you now. All right. So the video doesn't want to play, and so what we have.
What we'll do is we'll include a link in the for everybody that does sign up. They'll be able to get the link and watch the video.
Okay, perfect. Thanks. I appreciate that, Sam. So it's just a fun little video here. Just take an opportunity to watch that, and you actually see we are a very high-tech law firm. So what we do is we would send a video link like this, and when doing the signing process, you would actually be signing right on your cell phone. So, and that's what the video is going to show you.
Let me see if we can get the video up as well.
Sure. And then so we are also the true fixed fee law firm. So one of the biggest complaints lawyers get, or I hear about lawyers, is that lawyers' fees are never what they disclose them to be. They always say, "Oh, well, my lawyer said they're going to charge me $750 for my purchase, but it ended up costing me $2,300." And the reason why is because the lawyers have their fee plus the out-of-pocket disbursements, the things that they pay on your behalf. I've been doing this long enough, and I've done so many deals that I can average out a cost on a deal that I know what it's going to cost, right? I don't need to charge a separate fee and disbursements. When you do enough deals, you can average out your costs. So we are the fixed fee law firm. We charge $17.99 for a purchase, $11.99 for a sale, $11.99 for a refinance. And if you bring your purchase and sale to us, you get a discount of $100 off each. So you get your purchase and sale down to $27.99. Now the HST is in addition, and there also is land transfer tax on the purchase and the any of the purchases. Okay. We are located, as Sam mentioned, in Waterloo, but we do, as I mentioned, virtual signings. My license is good right across Ontario, so anywhere in Ontario. If the property, I've done properties that have been on islands, real estate transactions for properties that are on islands up in James Bay, in the Hudson Bay. So properties anywhere, we can assist you. Anywhere in Ontario, my license covers the entire province. So thanks, Sam, for having me.
Excellent, Jeff. Thanks so much for being on. So we'll make sure that everybody does get a copy of that video in the link there, presentation.
Thank you.
And if someone's going through a situation where they're looking at a marital breakdown, they're thinking about selling their property, what would be the best step to take first, and in this whole thing to help them?
It depends if they're amicable. If they're amicable, they should have a conversation and just be honest with each other, right? They should both agree that they can sell the property. And once again, the money can be held in trust. So if they both agree it's best to sell the property, then get the property listed, especially right now. The market is so hot right now. I think there's only 46 properties in the Waterloo region on 46 properties in the whole Waterloo region available right now. So you have a great opportunity right now. If you're looking at selling your property, get it on the market right now, right? But beyond that, the idea is be honest, talk to each other, and understand that you can still sell the property and hold the money in trust while you work out your details. It might be worthwhile to seek out a family law lawyer for more information. I'm not a family law lawyer, so I'm only doing this presentation as an explanation on what I see on my side, but it's definitely best to get some information from a family law lawyer or a mediation service.
What we'll do as well is if you do book a call with myself or Jeff, so with our team, what we'd be able to do is help you with a market value, discuss market conditions in the sale of your home, and timelines, where you're at in the process of separation, or whatever that is, and then making sure that you have access to our concierge so you can get that information of a family law lawyer that can help you work this out while you have this property for sale. And I think it's great that you said that too, because a lot of people think that you have to have all the separation completed, the agreements, all the assets before selling it, and that's not true. And it's great to hear that you can move forward right now.
Correct. Yeah.
Awesome. So what I'll do here is now I'm going to let them know where they can find you. We have that.
Please.
If you are considering selling your property, you're not sure about getting a value, understanding the process, how our team can help, you can text the word forward to 519-574-3532. We're happy to help any way we can. Make sure that this is a new forward, fresh start for you and your family. And also you can reach Jeff Rabinal and Rabinal Law at his team here in the area.
Yeah, and so you can reach us at rabinalaw.ca.
rabinalaw.ca. Perfect. All right, Jeff, thanks for having us on here. We appreciate all the great value we got today.
All right, thanks for having me, Sam. Great seeing you again, and I'll talk to you soon.
Thanks again. Talk soon.
Okay.